This is the plaintiff, Andrew Stamp. He says he's an attorney who went above and beyond for his client, the defendant, and the guy's trying to stiff him. The defendant retained his services because the city was coming after him for having a junkyard at his house.
Before we even get into the courtroom fight, here's the real issue. Was this actually a lawyer-client relationship, or did one side genuinely believe this was just friendly advice? That distinction could decide whether that $750 is owed, or whether this entire lawsuit falls apart. What do you think? If a lawyer gives you hours of legal advice without a signed retainer, should you assume it's free?
Due to the fact the defendant's a hoarder of junked-up cars. He deserves to be paid, doesn't work for free, and is suing for the $750 he's owed. This is the defendant, Dan Gregoris. He says he and the plaintiff made a connection like a friend, not someone he was hiring. They never talked about monetary compensation, and he thought the guy was just giving him some friendly advice, that's all. Owe him all this money? No way. He's accused of being a junkyard dog. The defendant has filed a countersuit for $3,500 for bad vehicle advice given and punitive damages.
All parties, please raise your right hands.
And welcome back to the People's Court. Next case in the docket. The plaintiff is a lawyer who was helping the defendant fight the city over his yard, which was filled with junk. But the defendant says there was never any talk of money. It's the case of, I'm in a funk over your junk.
Goodness. Okay, Andrew Stamp, you are suing Dan Gregoris. Okay, for $750 in legal fees. You say you're actually out $1,100, but in your small claims jurisdiction to go non-jury, you reduced it to $750. For legal fees that he has not paid you, you have a counterclaim against him for $3,500, $500 of it for car advice you gave him.
Actually, Your Honor, it's for my time spent to research this case.
I sort of liked it better when it was car advice. And $3,000 for punitive damages because you need to be punished. What's going on?
Good morning, Your Honor. Defendant first contacted me by telephone in late January of 2010. He had been convicted in municipal court in City of Damascus for code violations, for land use code violations.
Okay.
He had filed an appeal.
For what? What was it? What is it? What was the city's problem?
The city claimed a nuisance.
What did they claim was the nuisance?
One of my building collapsed. I had to pull out everything in an emergency. The code enforcement officer came over, claimed I cannot have that on my property.
What on your property?
Your Honor, basically had a...
Hold on, I'm not talking to you. Go ahead.
My cars and...
How many cars?
Part of the 18.
How many?
18.
18 cars?
Cars are my hobby.
Clearly.
I'm not making a business out of it. I just like old cars, and I'm never in my life went to a mechanic.
Okay.
But they were in the building.
Is this a building, or is this a commercial building, or is this a home?
It was a utility building. It is a property with a house with everything, but it's a 2 acre. It's a 2 acre. It was rural. They changed the zoning.
Yes or no residential?
Yes.
Okay.
But it was rural.
Okay.
So
they still have rules. They didn't like it. They didn't like 18 cars there. Yes. So the bottom line is the city of Damascus didn't like it. You went to a hearing. You represented yourself, I guess, at the hearing? And that did not go well for you. He came to see you because he wanted to hire you to handle the appeal?
Yes, ma'am.
Okay, and did he get a phone call first?
Right.
Did he just show up?
First, we had a telephone interview, gave him a free consultation over the phone. We discussed the case for about 20 or 30 minutes. During that time, he explained the facts of the case to me. I explained to him that he needed to come into my office and see me. I'd charge him $200 an hour.
You said that?
Yes.
Okay, well, how about you wrote that?
And this is where the case gets complicated. A retainer isn't just about collecting money up front. It can also document the terms of the professional relationship. Without that written agreement, we're left with two completely different versions of what happened. One says, "You hired me." The other says, "You were helping me as a friend." And now the judge has to figure out which story the evidence actually supports.
Retainer?
No, I did not get a...
Do you normally get retainers with your clients?
Usually what happens is they'll come in and meet with me, and during the course of the initial meeting, we'll get a retainer.
But that didn't happen here either.
It didn't happen there because it was rapidly apparent to me that the case was not, I was not going to end up representing him in court, that it
Why would I'm sorry, that doesn't make any sense, because even though you didn't represent him in court, you want to get paid, and the retainer's to get paid.
Right, but
The retainer is so that there's not this question about what he agreed to and what he didn't agree to, because watch this. Watch this, counselor. Did you agree to pay him $200 an hour?
Your Honor, never without.
That's why lawyers get a retainer. That's why the Bar Association recommends a retainer, so that you don't end up in this animosity
Yes, ma'am.
with your client.
I'm fully aware of that.
Okay, so why don't you get retainers?
I do usually get retainers. This case was just over before it started, basically.
Okay,
I mean, most of my cases.
but it wasn't over before $1,100 worth of legal fees.
That's
So,
right.
all right, so talk to me. What happened?
So he agreed that we would go out and look at the site, and went out there, looked at the property, quickly determined that, in fact, that if he went forward with this appeal, he was not only going to lose, but he was probably going to be deemed frivolous, and that he would end up paying the attorney fees of the city. It was clearly within what would be called junkyard. So
Because what? Because the cars were so old and
it was
battered?
just, I mean, I have Exhibit
Yeah, let me
2
see.
shows a photograph. This is his property in 2009. By the time I looked at it, it looked a little more organized.
Notice the judge is separating two different questions: whether there was a formal written agreement, and whether the lawyer actually performed valuable work. Even without paperwork, the court can still consider the parties' conduct and whether services were provided with an expectation of payment. But the defendant's "I thought it was free" argument is now facing a serious problem, especially because he admits the lawyer was giving him professional advice.
This and that.
Oh my God. This is what the city was complaining about.
Yes, ma'am.
Okay. Can neighbors see this or no?
That's
Just
taken.
one neighbor.
One neighbor.
And I never had problems until somebody else moved in the area, and she complained about the view.
Right.
The view.
Yeah, yeah.
But most of them are materials for the metal building which collapsed. And collapsed over the cars.
I know, but when something collapses, you have to clean it up. You can't leave it there.
True.
For years. All right, so at that time, you decide, you tell him, look, this is meritless. Don't waste your money. You're throwing good money after bad. Just let it go and clean it up.
That's right.
And you tell him that. All right. Now, let me hear from you, okay? Because according to you, you thought he was your friend?
So he didn't get a retainer agreement signed. Should he get paid?
Yes.
Why?
There was no oral agreement.
Lawyers are supposed to get retainer signed.
Yeah, they should get that retainer.
Does he get money?
No, he shouldn't.
Even if he did work, does he get money?
Yes.
Yes,
He gets money.
yes, they do.
Okay, we'll find out going inside the courtroom.
Your Honor, I cannot prove the negative. It was no agreement, no contract. From the beginning, I told him I'm looking for pro bono, excuse me.
Oh, pro bono?
Pro bono, yes.
Wait, you walk in and you say, hey, I want advice and I want it for free?
I want to know if I could advise for free because of my financial problem at that time. And he said...
You own property. How are you going to qualify for pro bono owning property? You understand what pro bono means, right? Everybody wants it free.
I didn't know much about it, Your Honor.
You don't think that lawyers deserve to get paid for the advice that they're giving you?
Absolutely.
How do you have an expectation that it's free?
Absolutely, but before, when plumber comes to your house, is giving you an estimate.
Yeah, you know how those plumbers, first they fix a few faucets for free. And then you see if you're going to hire him to do the main bathroom. Yeah, you know how that's always happened. What do you do for a living? What's your job?
I'm by trade, or what I'm right now I'm unemployed, but by trade I'm a metrology engineer in the semiconductor industry.
Would it be fair to say you expect to get paid when you work?
Yes, but I'm
Okay.
giving a lot of advice
Why
for
would
free.
you think, okay, that he was going to work for free? Because really, lawyers, I mean, because you two were such pals, like what made you think it was, you said really we were talking like friends. What made you say that he was your friend? What did he do that made you feel
Your
that
Honor,
it was like...
I consider the visit he paid me on the 30th January, like he said, pleasantry, small talk. He never said he's gonna charge me for anything. I believed his visit to my property was only because he was curious to see my cars, and we were talking about maintenance on his cars. Also, he showed me one of his hobby, which was one of my hobby when I was young, photographs, and he showed me his album with nudie girls, whatever.
Okay.
Nice. No, I'm telling you exactly what happened. 2 hours, we talk about everything else. Maybe we talk 10 minutes about the property and all the other, but I consider the advice I'm giving him.
Stop. Mr. Stamp, is there any truth to what he's saying, that you had an album with...
No, that's I don't know where that's coming from.
Was there a photo album?
No.
There was never a photo album?
No.
There were no nudie girls?
No.
There was never a photo album?
No.
At all?
No.
Do you have any idea what he's talking about?
He's on the road. I can't believe this.
No. I have no idea what he's talking about.
How long did you spend at the site talking with him about stuff that was not the site?
Probably about half an hour or so.
And how long did you spend talking about the site?
About half an hour.
Does it take half an hour to look around and say, hey, dude, this isn't going to fly? I mean, that doesn't take half an hour.
Yeah, I'm estimating times, but...
Okay,
no.
I'm going to estimate times too. What I'm going to do is, I do not agree with you that in fact, well, let's talk about your counterclaim.
And now the judge has had enough. This isn't just about whether someone owes $750 anymore. The credibility of both sides is taking a beating. A tiny wording dispute in an email has turned into a major argument over what was actually requested. When a case comes down to conflicting stories, written evidence can become incredibly important. So which version would you trust here, the email itself, or the explanation being given for it?
First, your counterclaim is $500. Now you've changed it. It used to be that for the car advice you gave, but now you want it to be for your time in having to prepare to come here today.
I spend a lot of time on the internet researching for everything.
Okay, but you got nothing but time right now, apparently.
True,
And
I'm not gonna, Your Honor, I don't judge
it's
for
not
advice.
like lost wages or something, right?
There's the ruling. $600 for the plaintiff, not the full $750 he requested, and $0 for the defendant's counterclaim. The judge essentially found that some compensation was justified, while also making it clear that the lawyer's failure to get the agreement in writing was a major mistake. It's a classic small claims lesson. Doing the work and proving the terms are two very different things.
Judge for advice.
Okay.
But also, Your Honor, if you want to see, he's using an email where I ask his advice because I wanted to pursue the cancellation, the papers. He's changing this email in his response, in his memorandum. He's changing the word I with you, like I asked him to do that.
Let me see.
I never asked him. He's giving a completely different meaning to the email.
He's right about that.
That's why I wrote this SIC. I assumed it was a typo in his part.
Wait, you wrote, second, I wanted to ask you if you could, and you wrote SIC, there is a certain procedure to stop the appeal. You thought when he said, I wanted to...
And that's the takeaway. Small claims court is often about resolving a dispute efficiently without the cost and complexity of a full lawsuit. But this case also delivers an even bigger lesson. If money, professional services, or expectations are involved, get the agreement in writing. Because once the paperwork is missing, a simple misunderstanding can turn into a courtroom battle.
Ask you if I could, there is a certain procedure to stop the appeal. I just received a letter. Are there any forms I have to submit? You thought that he meant you submit? So you put SIC as though that was a typo? Are you kidding me?
Yes, ma'am.
Seriously?
Yes.
Oh, come on, man. Are you kidding me? We're
here's
done.
Here's what I wrote
We're
in
done.
response.
Just stop, okay? First of all, you are not a good lawyer and you need to get better. You need to get retainers in every single case. If it's worth you coming to court and fighting to get $1,100 or $750 or a penny, it's worth you taking 4 seconds and having it in writing. Okay?
Yes, ma'am.
And you have a lot of nerve. You think that a guy who you don't know from a hole in the wall, because it's not like you met him at a bar, and he was just sitting there drinking, and then he gave you legal advice, and then he presented you with a bill. That I could understand. It's a guy who you go and see. You expect to get paid if you work. You know that he's a lawyer. You know that he has to put food on the table, and you know that he's coming to visit you, and you know that you took up his time. How could you think there wasn't going to be some charge? All right? $200 an hour is reasonable. I think all of this, if you take away all the fluff, is probably worth 3 hours. $600 verdict for the plaintiff, $0 on your counterclaim.
Thank you.
Okay, FYI, sometimes you go to small claims court even if you're not going to get the full judgment of what you're out because it's faster and it's a lot cheaper and you don't have to hire a lawyer.